Calling case 24005418, People versus Mark Swanigan. We're here for a final conference. Appearances, please.
Good morning, Your Honor. Andrew Tyler for the People, P 87431.
Good morning, Your Honor. Rita White on behalf of Mr. Mark Swanigan, P 63046.
Good morning. And good morning, Mr. Swanigan. Please remove your outer wear, Mr. Swanigan. Thank you. State your name for the record, please, sir.
Mark Swanigan.
Thank you. Right, we're here for a motion to suppress the search warrant and ultimately warrant dismissal. And I'm not clear, Ms. White, whether you're requesting a Frank's hearing. I'm not, and admittedly, I have not read the entire motion yet. I'm perusing it. Did you allege in it, and I missed it, that the affiant made false or misleading statements, or is it just the challenge to the reliability of the informant?
I can't hear.
Okay, let me try again. Can you hear me now?
A little better.
Okay. In your motion, which I haven't read word for word yet, but I will read it. In perusing it, I saw that you were challenging the reliability of the informant.
Correct.
Were you also challenging whether the affiant made false or misleading statements? I don't see that, and I want to be sure I'm not missing that if that's what you are alleging.
All sort of what?
What was your question?
You said the affiant made.
Are you alleging that the affiant made false or misleading statements as well? In other words, are you requesting a Frank's hearing?
I am requesting a Frank's hearing.
Okay. So in the motion, does it allege that the officer made false or misleading statements?
Your Honor, the main focus or main issue that I'm addressing is PC, probable cause. In terms of making false allegations, the OIC, that's why it wasn't titled as a Frank's hearing, because I'm mainly focusing on the probable cause of the information provided.
Okay, so then so the answer then to my question earlier is that you're not alleging that false or misleading statements were made.
Yes, outside of the affiant being misleading, I can't, determine false, but his statements were very general, or the affiant statements were very general. So it's mainly probable cause.
Okay. I think it's exclusively probable cause, because for Frank's, it would need to be false and misleading. And I don't think you're saying false necessarily. Okay, so do we need an evidentiary hearing? With respect,
I would like the affiant present regarding this matter, because there's just I would like the affiant present, yes.
If I may, Your Honor.
yes, go ahead.
On a challenge to the search warrant, I think the proper inquiry would be just into the four corners of the affidavit and search warrant itself. I think unless there's a finding that something such as a false or misleading statement and a request for a Frank's hearing, I think it'd actually be improper to bring the affiant in. I think the proper analysis is looking at the four corners of the search warrant and determining whether the magistrate had a substantial basis there for determining that there was a fair probability that evidence would be found where they attempted to search.
Okay, do you want to respond? I'm listening.
Your Honor, like I said before, the main factor issues is probable cause. Ideally, I would like to have the affiant here, but really this search warrant within the four corners, I believe we could go we move forward independently on the search warrant, the four corners, because I don't believe just a search warrant in and of itself establishes probable cause. So.
Okay. So I agree with the people that we don't need an evidentiary hearing, because that would be a Frank's hearing. And I think that the basis for the relief that you're requesting isn't that the affiant lied or misled well, that the statements were false and purposefully misleading. So, Mr. Swanigan and Mr. Tyler, you can have a seat, and if you'd like to have oral argument, we'll take that now, Ms. White.
Yes, Your Honor, I did file this motion a week ago to address the actual search warrant that was basically triggered this matter for Mr. Swanigan to even be present to my right, to my left. What we have here is a search warrant that we all are learned to know that a magistrate has the authority to authorize a search warrant if probable cause exists to proceed with a search warrant. What I, after reviewing the affidavit and also reviewing the investigator's report, regardless, I don't believe there's actual probable cause to identify the house the house that was raided to actually enter into. There's testimony, there's actually in the affidavit, one main extremely troubling issue is that there's a lot of statements, but when it comes to actually connecting the purpose and the main purpose of the actual search warrant was allegations, belief that there was drugs being dealt in and out of the home of 6455 Banner. From the search warrant in and of itself, I believe that the information provided in the search warrant under the affiant Mr. Officer OIC Detective Wengrowski is just a lot of speculation. Speculation does not equate probable cause. Probably versus, I don't know, maybe let's just go for it. I believe it's let's just go for it. There's in the affidavit, it specifically indicated that Mr. Swanigan, the only identification of Mr. Swanigan at the scene was on a lawn. On
a lawn.
And what the affidavit specifically indicates is based on observing Mr. Swanigan on the front lawn, well, he must be living there. I don't believe that's enough to establish that an individual has possessory or ownership interest in the location. There was in the affidavit, it specifically indicated that Earl Brown, a check was run on Mr. Earl Brown, and he was deemed as the actual legal registered owner of the home. Was there any information in the affidavit to indicate that Mr. Swanigan had any connection to the home? No. In addition to that, the officer and the officer Trooper Lane testified that they spoke with an actual anonymous informant. This informant, I would like to contest the reliability of this informant, given the fact that just a statement without any more details is very, very weak in terms of establishing probable cause. Yes, this informant indicated that he believes the three, Danielle Norris and Earl Brown, as Mr. Swanigan, were dealing drugs in the house. But we need to connect that. And to connect that, we need to have some type of statement or some type of information in the search warrant indicating that this informant directly observed my client involved in a drug buy, Danielle Norris or Earl Brown. Also, in addition to that, there needs to be dates, times. Just to make a blanket statement, I don't believe that rises to the level of probable cause. Now, in regards to the other factors that the OIC Wengrowski utilized to establish belief he had probable cause was cars coming in and out of the driveway. 2 cars. One was Earl Brown's, where he legally went to his house, parked the car, and went into his house. And now Officer Detective Wengrowski believes that indicates a short buy or short sale of drug dealing. Along with that, there was another vehicle, a black truck that came to the driveway and then left. There was nothing in the search warrant to indicate that outside of a car coming into the driveway and leaving, there was more other than a belief, an actual speculation that there was a drug buy. Yes, there was a lady that was on a bike that had drugs, but again, we have to connect Mr. Swanigan to all of these transactions or any of the transactions. Not one part of the search warrant indicates that Mr. Swanigan was observed coming in and out of the house. He was never observed in the house or out of the house. Mr. Swanigan was never observed in any type of hand-to-hand exchanges of anything at the house or anywhere. And Mr. Swanigan's priors, that really is completely irrelevant because it doesn't matter. A person can have priors 10, 20 years ago or 3 years ago, but is it connected to the date, time, and location of the search warrant execution of 6455 Banner? No, so that is not something that you can use. Well, let's profile this person just because he has priors. He must be dealing drugs. We have to show, sorry. We have to show some type of explicit eyewitness statements that Mr. Swanigan was observed in the home dealing drugs or having any involvement with a gun, drugs, nothing other than speculative statements. An informant just stating that these people are dealing drugs in a house, and then they see my client on the lawn, and they don't indicate we saw him on this date, that date, and another date on the lawn, or even mainly inside the house. There's not enough PC or probable cause to establish that there are any drugs being dealt out in that house. Now, if there was an actual, the affidavit indicated that there was a short sale that we observed this lady in the bike transacting drugs with someone from the house, and the person would have to be identified who is transacting with who, that may be probable cause. But if you're just basically speculating, well, Mr. Swanigan must be the dealer because he has this prior and he was on the lawn, that does not establish PC. So I'd ask that this search warrant be quashed and dismissed based on the fact that you can't have a search warrant when you don't have any evidence to connect the person to the search warrant. None. So we can't just assume, ASSUME, that my client was dealing drugs or any of the parties in that house were dealing drugs, but just because you see two cars coming back and forth, going into the driveway, one car being the owner, and there is no eyewitness observations of any drug sales. Even the black car that came out and was indicated that they went into the driveway, maybe spoke with someone and then left. Why wasn't that car stopped? Why didn't the officer stop that car for one reason or the other to determine if there was even specific viewed drugs in that vehicle or any type of paraphernalia to prove or establish that there was some type of drug sale? Just speculation is not enough. Probable cause, yes, but speculation and probable cause are two different terms. And so I would just ask that the search warrant be quashed, given the fact that Mr. Swanigan was never observed with a gun, dealing drugs, never observed in the home, never observed sleeping in the home with pajamas, sleeping in the home or anything connected to that home, other than we believe possibly speculatively that he had something to do with dealing drugs along with the other individuals connected to that search warrant. So I would ask that it be quashed.
One moment, please, Mr. Dyer. Mr. Fryland?
Yes, thank you, Your Honor. So I know you've not had a long time to review my brief, but it is fairly law heavy. And I do want to start that way to kind of walk through the law as it pertains to this before getting into some of the facts and the probable cause determination. Determining what is required for probable cause, it's the magistrate need only to conclude that there's a fair probability that the evidence be in the place indicated in the search warrant. That's the standard that the magistrate has to meet. And that's a quote from People v. Russo, RUSSO, which is 439 MISH 584. And it's a 1992 case. There's some discussion about what would not reach probable cause. And one of those things that would not reach probable cause is just conclusory language. Sufficient information has to be presented to the magistrate to allow the official to determine probable cause. He cannot just merely ratify conclusions of others. So in other words, the affidavit can't just say, I believe that based on everything I've seen, I believe that drugs are being trafficked here. And the magistrate then says, well, if you believe it, then it must be good. That's what we want to avoid. The inferences being drawn should be drawn by the neutral magistrate, not by the police officers who are asking for the warrant. So I do have a fairly lengthy quote from Illinois v. Gates talking about what probable cause is. And it talks about how we're not dealing with hard certainties, we're dealing with probabilities. And there's some difficulty in figuring out exactly what standard to put up. Probable cause is a fluid concept, turning on the assessment of probabilities in particular factual contexts, not readily or even usefully reduced to a neat set of legal rules. So there's some Gates is kind of setting up that this is a difficult analysis to do. And Illinois v. Gates is 462 U.S. 213. That's a 1983 case. There was a bit of discussion in the courts, some back and forth about what the standard of review here is, whether it was de novo, whether it was abuse of discretion. Ultimately, the courts settled on kind of an in-between standard. And even though several courts had already made determinations, but the standard is kind of in between de novo and abuse of discretion. The standard there is the reviewing court should ensure that the magistrate had a substantial basis for concluding that probable cause existed. So substantial basis is kind of the language that we're looking at. The magistrate did make this conclusion that probable cause existed. And when reviewing, the court should look at it and say, well, was there a substantial basis for the magistrate to draw that conclusion, given the facts that are alleged? Magistrate's determination of probable cause should be paid great deference by reviewing courts. The court in Gates again says a grudging or negative attitude by reviewing courts towards warrants is inconsistent with the Fourth Amendment's strong preference for searches conducted pursuant to a warrant. And it also talks, Gates again says courts should not invalidate warrants by interpreting affidavits in a hyper-technical rather than common sense manner. There's a lot of discussion about the fact that the people who are writing these warrants are police officers, not lawyers. So looking at the warrants in a hyper-technical and a legal sense isn't really appropriate, and it actually undermines the purpose of the warrant process, right? We're asking these police officers to investigate and to write down what they've found, and the conclusions be drawn by the magistrate, but attacking the search warrants in a legal sense or expecting legal standards from the police officers who write them is not what we should be doing. Moving on to just hearsay statements in general, being allowed in search warrants. Statements made by a non-affiant can be used in probable cause determinations. And the leading case on that is Draper v. United States, which is 358 U.S. 307. It's a 1959 case. A quick note on that is Draper is about probable cause to arrest, for a police officer to arrest. It was brought into the analysis for probable cause to issue a search warrant as well by both Michigan and U.S. cases. That one is the case where officers told that somebody wearing a very specific set of clothes would be carrying a briefcase, and inside the briefcase would be drugs, and he would be arriving at this train station at this time. Pretty well-known case in law schools. The officer shows up, sees that guy wearing those exact clothes, carrying a briefcase at that exact time, and then observes the man and makes an arrest. And one of the challenges to that was that hearsay should not have been allowed in the search warrant, right? The affiant should have been the only one doing the investigation, should have been the only one putting down statements. And the court said that's not the standard there, right? And it takes a lot of time to separate what's required at trial and what trial protections and trial rights are versus what's required for probable cause determination. And again, the difference between requiring a legal standard for the officers who are performing this work, right? So there's a very different thing. And there's a part in there where it talks about basically if you were to exclude all hearsay, and if you were to hold it to a higher standard and all this, basically you're requiring proof beyond a reasonable doubt that someone did something wrong at trial before you can even issue a search warrant, right? That logic doesn't follow. This is an entry level requirement for probable cause. So hearsay can be allowed. Obviously, who the declarant is there can be considered, can be important, but hearsay can be allowed. And in that case, there was a lot of discussion about how corroborative it was, how specific what this person would be wearing, when he would be arriving, exactly where he'd be, what he'd be carrying, and what would be in the briefcase, which was drugs, and eventually that was found. Now, specifically regarding confidential informants, so not just hearsay in general, but specifically when the hearsay is coming from somebody who is unnamed.
Before you continue,
Yep.
Mr. Tyler, are we making a distinction between confidential and anonymous informants?
I am not making a distinction. No. There are two, the two are named or unnamed, and unnamed being any confidential or anonymous or such.
Thank you.
So talking now about confidential informants, there was, prior to Illinois v. Gates, there were two Supreme Court cases that dealt with determining what would be appropriate for including a hearsay statement by an anonymous source. Those cases are Spinelli v. United States, 393 U.S. 410, and Aguilar v. Texas, which is 378 U.S. 108. Both of those set up a two-pronged test that would have to be considered in order to allow a hearsay statement by an unnamed witness, by an unnamed declarant. And the two prongs had to do with reliability or verifiability, and the other had to do with some basis for personal knowledge, right? Now, Illinois v. Gates overturned that line of cases. That line of cases is no longer good law. What Illinois v. Gates was doing is saying, when a judge is looking at this, when a magistrate's looking at this initially and when it's being reviewed, the test is always going to be a totality of the circumstances test. To focus in on these two factors, the reliability of the source and their basis of personal knowledge alone, and to, in a hyper-technical sense, fix those two as being the only like check boxes that have to be filled to move forward, isn't appropriate. We're not doing that anymore. It has to be a totality of the circumstances. And of course, you can still consider those things. Hey, how did this person know what they were saying? And do we know this person to be reliable or unreliable? Those can be considered, but to expect those in every single situation to be boxes that have to be checked off is no longer good law. So in Gates, the facts are that a detailed letter was sent anonymously accusing defendants of drug trafficking. The officers did a little bit of investigation and put the letter and also the results of their investigation together and sent it in to ask for a warrant. It was the Illinois Supreme Court that read those requirements as being kind of hyper technical and saying neither of these are filled out, right? They said, okay, there is some corroboration between what the police were observing and what the letter alleges. There's some corroboration, but those are all innocent details, right? It's just, yeah, that person's there, and yes, this, that person lives there and does go from this place to that place, whatever. So that's not really important, is what the Illinois Supreme Court said. And also, there's nothing in the letter at all that says how this person knows this stuff. It's very detailed, but how would that person have any knowledge of that? So these two boxes are not checked. That's what the Illinois Supreme Court said. But the U.S. Supreme Court, in overturning the Illinois Supreme Court, said you're focusing too hyper-technically. It's not whether these two boxes are checked. The question is still a totality of circumstances test. And what we're asking is, given this letter and the investigation that was done by the police, when we put them together, again, do we have a fair probability that when police ask to search that house, that there would be drugs in that house? And when we look at it completely like that, yes, the answer is yes, we do. And so the Illinois Supreme Court was overturned. Michigan does have a version of the two-prong test in its statutes. That's MCL section 780.653. And it does talk through if a magistrate's finding of reasonable probable cause, it has to be based on all the facts related, and it may be based on information applied to the complainant by a named or unnamed person if the evidence contains one of the following. Section A is for a named witness, and Section B is for an unnamed witness. For an unnamed witness, it says if the person is unnamed, affirmative allegations from which the judge or district magistrate may conclude that a person spoke with personal knowledge of the information, and either that the unnamed person is credible or that the information is reliable. So again, we do have a statutory two-prong test, and that two-prong test doesn't say that there need to be specific declarations in the warrant. what it requires is that there's enough in the warrant that the magistrate can draw an inference that this person has some basis of personal knowledge, and also either that this person is credible over a period of time, or that the information that they provided has some reliability to it, right? That's that two-pronged test. Now, I do also want to talk about corroboration, right? Because on the one hand, if we're talking about issuing a search warrant based solely on a statement made by an informant, especially a confidential informant, that can seem a little tricky. But most of the time, that's not what we're doing, right? Most of the time, police officers are going to follow up on an investigation. So how does this work with corroboration? If we have an informant say something, and then, like as in Gates, there's some investigation that confirms some of the details, how does that look? So I want to bring this to Michigan law now. I want to discuss People v. Sellers, which is 153 Mich. App 22. And the quote from there is, a warrant may issue on probable cause if the police have conducted an independent investigation to confirm the accuracy and reliability of information provided by a confidential informant, regardless of the knowledge and reliability of the source, right? So the logic here again is, okay, so if someone says, hey, this person's dealing drugs, and the police observe that person dealing drugs, it doesn't matter how reliable the source is, right? Probable cause is determined because the officers had probable cause by itself, right? Now, generally speaking, that won't be the case in especially search warrants that are contested, right? Generally, it's going to be a mix of the two things. We have an informant's tip, but we also have some investigation, and together they equal probable cause, and that's allowed as well. So specifically in Sellers, police received an anonymous tip that the defendant would be delivered cocaine, and he would be delivered cocaine in a Toyota Supra, and it was a copper-colored Toyota Supra. So police set up surveillance. They observed a male driving a copper Toyota pull into the driveway. He goes inside. He comes back into the Toyota. When he drives away, police pull after him and find out that he's that something was wrong. I think he was driving without a license, or he was driving without insurance or something like that. So they pull him over. They end up searching the car, and they do find cocaine in the car. So together, those two things are what led them to believe that there would be cocaine in the house if they searched it, right? The tip itself would probably not have been enough. And also the fact that someone went into a house, came back and drove away and had cocaine in his car, that's not going to be enough, right? But together it paints a picture, right? We have the copper Toyota going into the house, just as the informant said it would. It comes out, now that there's cocaine in the car as well, an inference could be that some of the cocaine was delivered and some wasn't. So together, that there is a fair probability that inside that house would be cocaine, like the informant said there would be. The defense in this case did try to argue that this two-pronged test for credibility, which we talked about in MCL 78653, wasn't met, right? Because there wasn't any discussion about how this person knew that, and there wasn't any track record to show that this person was a credible source, and there might have been a little bit of corroboration, but it shouldn't have been enough, right? And the court in Sellers says, we're not going to strike anything from the warrant here. The Michigan case, the leading Michigan case on the interpretation of MCL 78653, which we'll talk about in a little bit, that case had suppressed this search warrant, results of a search warrant, given violations of that statute. So the defense wanted suppression in this search warrant as well. And the court in Sellers says, we're not going to do that. We're not going to follow the logic of Sherbein. Instead, and that quote from the beginning that I said about the corroboration is from is from Sellers when it says that. Right. So it determined that MCL 78653 applies only to cases where the affidavit discloses reliance solely on a confidential informant, or solely on an informant, whether confidential or not. So it says, When the details are confirmed by independent investigation by the police, the magistrate may rely on that independent confirmation as well as the details furnished by the informant to find probable cause. Right. So they're saying this requirement that you have to show them that they're credible, and you have to show that they have some reliability, and you have to show that they have a basis for this. That only applies if the only thing you're submitting for a search warrant is a request, right? In this case, we have confirmation. The police saw these things together. We can put these together and we can make the determination that probable cause exists. I also want to talk about People v. Keller, which is 479 Mich 467. In this case, police are receiving information defendants growing and selling large amounts of marijuana in his house. So police are doing investigation. Eventually, they end up doing a trash pull. The bags are thrown out from the house. They go through the trash and look, and they see a roach of marijuana, and they also see a green leafy substance on the side of a pizza box. They put this together. They go and ask for a warrant to search the house, and they're given a warrant. The search warrant is attacked. Okay. Court of Appeals dismissed the warrant, says, well, the informant didn't really say anything about personal knowledge. And when we're talking about reliability of the information, there's kind of a mismatch here, right? Because the informant is saying, hey, they're dealing marijuana out of there. Not that they have some, but they're dealing some. And when you see one marijuana roach and you see some leafy substance on the side of a pizza box, that in no way corroborates what the informant is saying. There's kind of a mismatch. So the Court of Appeals says, hey, this isn't good, and we're tossing it out. It goes up to the Supreme Court, and the Michigan Supreme Court says, and a quote from the Court of Appeals says, well, this evidence is hardly evidence that would lead a reasonable person to believe that drug trafficking is occurring, right? So there's no corroboration. They dismiss that, and then it gets appealed. So first, the Court of Appeals is talking about this. I'm sorry, the Supreme Court of Michigan talks about the standard. They said, hey, you're reviewing this de novo. That's not appropriate. There ought to be great deference to the magistrate's opinion. But then they also say to the Court of Appeals, your logic is fine, but the way you're looking at it is wrong. You are asking the question whether the other investigation is sufficient to corroborate what the informant said. In other words, you're making this a test of the informer's credibility. That's what you're looking at. They said that's not what you're supposed to be looking at. The thing you're supposed to be asking is there a substantial basis to believe that there's a fair probability that evidence would be recovered? That's the standard. That's what you're supposed to be looking at. And when you have an informant say, hey, people are dealing drugs out of that house, and also you see marijuana in a trash bag that was thrown out of the house, the answer is yes. The answer is yes. There's a fair likelihood that something, some contraband of some type, specifically probably marijuana, is located in that house. So we shouldn't be looking at, is there enough in here for us to declare with certainty that the confidential informant is reliable? That's not the question. The question is always and should always be, is there a fair probability that that in that house there's contraband that would be discovered if the search warrant were executed? So there is some discussion by the dissent, where the dissent in that case says, okay, but the search warrant also asked for the ability to search for evidence of drug trafficking. So it says, well, given the majority's logic here, shouldn't there be kind of an issue because of that mismatch, right? If all you're saying is you have evidence for is that marijuana is in the house, then you don't have enough evidence for drug trafficking. And the majority says, okay, we understand what you're saying, but first of all, what's the scope of the two? The scope is arguably broader if you're searching for marijuana or any evidence of the use of marijuana than if it's searching for like scales or other things like that. It'd be a broader search. So that's not really too relevant. And they say, ultimately, we don't have to decide any of that. So it's the dissent who kind of brings that up. But they said, even if you're right, though, and factually nothing was recovered like scales or something that would show distribution. So the court says, okay, even if you're right, we would just dismiss the stuff that was recovered under the improper section of the search warrant. Nothing was recovered under that section, so That's irrelevant. And they moved on. Both Keller and Sellers were asked to find a violation of 786.53, and the Keller court says the same thing the Sellers court did. 786.53 is not applicable when there's an additional basis beyond the affidavit, beyond the mere assertions of an informant. So here the warrant was predicated upon the trash pull, and it does a discussion of what the words based on means. It says that this warrant here is really based on the trash pull. It's not based on the words of the informers. So when it's together, 786.53 doesn't really come into play here. But 786.53 is still good law. So the question then becomes, what does it mean? What is it good for? What does it do? And after Gates, we know that the two-prong test is not a constitutional violation. But that doesn't mean that 780 doesn't mean anything. So now the question becomes, okay, if there's a statutory violation of 786.58 or 653, I'm sorry, 786.53, that doesn't rise to the level of constitutional violation. Is there a remedy that a defendant can ask for if there's a statutory violation but not a constitutional one? And both Sellers and Keller were decided after Gates. So they could have said, hey, Gates makes this statute unconstitutional or something. They didn't do that. They just said it doesn't apply, and they kind of pushed it to being solely for when it's just the word of an informant. It's People v. Hawkins that deals with the question of what if there's a statutory violation? What happens then? People v. Hawkins is 468 Nish 488. It's a 2003 case. In that case, all the parties agreed, yes, this statute was violated. It was a statutory violation. We all agreed with that. And the court said, well, we're suppressing based on that. And because we're suppressing, the case is dismissed. Prosecution appealed, says, okay, there was a violation, but suppression is not the correct remedy. It goes to the Michigan Supreme Court, and the Michigan Supreme Court agrees. Suppression is not the appropriate remedy for a statutory violation of 786.53. The Michigan Supreme Court there talks about how it's based on bad law now. It's based on the Aguilar and the other case, that two-prong test. So it's not a constitutional violation. It's just a statutory one. And they discuss the policy purpose behind an exclusionary rule. And they say, this is really to deter bad conduct. That's not really what it would be doing here if we were to apply it. So they overrule Sherbein, that case that we were talking about before. Sherbein was overruled because Sherbein held that if a violation of the statute, a statutory violation of MCL 786.53 should result in suppression, Hawkins overruled it, explicitly overruled, and said, this is just a statutory violation. The remedy is not suppression.
Did they overrule Sherbein merely because of the oh, I just lost my train of thought. One moment. What state would you just, the last sentence that you just made, if you could recall?
Certainly. Sherbein says that a statutory violation of 786.53 should result in suppression of the evidence
I remember
obtained in the search warrant.
So is it just the remedy in Sherbein that was reversed?
Kind of. By Hawkins, yes.
Yes, by Hawkins.
The constitutional implications, yes, by Illinois v. Gates. And additionally, the statutory interpretation of 786.53 done in Sherbein is irrelevant now because the statute was updated. So combined, Sherbein is really not applicable to anything we're doing here. So I also want to go through, that concludes the first section. That's the law here. Normally I wouldn't do this, but I do want to go through defense's motion to kind of talk about some of the law in the context of the broader scheme now, the law that defense brings up, and talk about, I think, how the court should consider what's being said, right? So first, in defense's motion, on page 2, there's a quote from Gates. And does the court have a copy that's following along?
Yes.
Okay, so in that middle paragraph that starts with the United States Constitution, the last full sentence says, to determine whether probable cause exists, a magistrate must evaluate quote, whether given all the circumstances, including the veracity and basis of knowledge of persons supplying hearsay information, there's a fair probability that contraband of or evidence of a crime will be found in a particular place, and a cite to Illinois v. Gates. The way this is written, there could be an implication drawn from this that veracity and basis of knowledge hold some exalted position in this analysis. But those are the two prongs that Gates is overturning, right? Gates is not saying, consider everything and especially these two. Gates is saying, hey, don't consider those two specially. Yeah, consider them. Yes, they're relevant, but they shouldn't be those check boxes like we were talking about before. So this quote is not saying put these two higher. It's actually bringing them down. And either inference could be drawn here, and I want to make sure that the court knows Gates is overturning that two-prong test. It's not setting these two up on kind of a pedestal here. There's also discussion of the exclusionary rule. Obviously, we know what the exclusionary rule is, but I would argue that it's not applicable here unless a constitutional violation is found, and that would have to be found through Gates, not through a two-prong test, and specifically not through 786.53, which, as we've discussed, Hawkins says exclusionary rule is not the remedy for a statutory violation there. On page 3, there's some discussion of Keller. Keller is the pizza box and the green leafy substance. So the quote or the discussion of Keller on page 3 says, affidavit in support of a search warrant doesn't provide a substantial basis for inferring fair probability that evidence of drug trafficking will be found at the house, even though an anonymous informant provided information that large quantities of marijuana are being sold and manufactured. It says alleged tip did not mention any other supportive descriptive information and was at significant odds with the discovery after trash pull of marijuana cigarette butt and possibly small amount of marijuana residue, which was not evidence of marijuana manufacturer delivery. The implication that could be drawn from this paragraph is that because of the mismatch, that there wasn't enough, the mismatch between what the informant said and what was actually discovered, there wasn't enough to issue a search warrant. That's not what Keller said. Keller said together they are enough, even though there's a little bit of a mismatch, and the majority didn't deal with the question of the scope or anything like that, saying, yeah, we understand what you're saying, we think you're wrong, but ultimately it's irrelevant, so we're not deciding that issue, right? Keller said it is enough. It is enough because, again, the question isn't, can we confirm everything that this confidential informant is saying to an absolute certainty? The question is always going to be, is there a fair probability that contraband exists? And together, these two things do make that a likely probability. On the bottom of page 3, there's discussion of MCL 786.53 that says informant's personal knowledge of information established probable cause for search, which is required if the informant is unnamed, should be derived from information provided or material facts, not merely recitations of the informant's having personal knowledge. That's not what MCL 786.53 says. MCL 786.53 says if there is that a magistrate can use named or unnamed hearsay, declarant, named or not named declarant's hearsay, and if there's if the declarant is unnamed, then what's required is that there be facts that the magistrate can make a determination. There needs to be facts on the page that the magistrate can make a determination of reliability and a basis of knowledge. There's also some discussion of Frank's issues. Suppression of evidence is required. The quote from the defense's motion: suppression of evidence is required even if the affidavit remains valid after exercising an erroneous statement when the statement was intentionally false or given with reckless disregard. That's, as we've discussed earlier, that's not at issue here. Also, this kind of a rabbit hole, but Lady support quotes Howie, and Howie does not say that. Either way, these are Michigan appeals cases. I think we'd all agree the United States Supreme Court Franks would control in that setting. Leaving that to the side, though, moving on to page 4, there's some discussion of People v. Harris bleeding into page 5, 191 Mishap 422. The statement here is that the court believed the specificity of the details provided by the informant in their case regarding shipment dates, defendant's name, address. They were substantial indicia to support a finding the informant spoke from personal knowledge. I'm not sure what case this is when I look up People v. Harris, I see a search warrant issue, but it's regarding an OWI.
I'm sorry, where are you?
Bottom of page 4, and then the site is on the top of page 5.
Oh, I see.
These, I don't see that these are the facts of Harris. Harris, like I said, regards an OWI. Again, the implication that could be drawn from this paragraph is that only in the case where there's such dramatic indicia of personal knowledge will a search warrant be approved. That inference is not supported by this statement, and this is not the correct case to make that assertion. In Harris, it's an OWI and it's a named informant. It's a different analysis. I do want to move down to page 7. There's some discussion of, in the center, there's People v. Broilo, Broilo, which is 58 Mishap 547. And in the center, it says there must be something more than the mere fact that people were coming and going at premises to be secured or to be searched, to give reasonable cause to believe the criminal activity is continuing and presently occurring. Such additional evidence could be information of or suspicious actions of the parties. Again, the implication here can be, well, if all that's going on is that people are coming and going, that can't be enough. Therefore, in this case, the fact that we have these 2 trucks pull up and then leave, you can't use that, or that cannot be enough. People v. Broilo, though, is about staleness. That's the question. In People v. Broilo, there were facts that there was drug trafficking going on at a house, and the search warrant or the affidavit went up until September 25th with all of the allegations. The only allegation, and the search warrant was issued on November 5th. So we're talking over a month. The only thing that the search warrant said continued between there was that an unusual number of people were at this house. So they said, hey, we think drug trafficking is going on in September. Then they say, and also a bunch of people keep coming and going to this house. And then, can we get a search warrant on November 5th? And the court says, no, right? You have to show that there's some continuing thing going on, right? The warrant that you're talking about is stale because there's not a fair probability that when you search the house on November 5th, there's going to be drugs unless you saw something continue, right? That's the question of Broilo. So here it says the mere fact that people were coming and going, the criminal activity is continuing and presently occurring. That's the issue they're talking about. So it's not saying that, hey, someone coming and going from the house can never be enough or doesn't mean anything, or suspicious. It says suspicious activity would, but people coming and going wouldn't. It's saying there's too long of a gap here, and there's nothing other than people are going to this house. So that's what Broilo is talking about. I would argue that has no relevance here, given that many of these allegations are made within 48 hours of the issuance of the search warrant, and some were made a little bit before. But we're not talking about an unexplained gap of a month. So then down on page 12, there's a long discussion about Sherbein. As we've discussed, Sherbein is overruled. Sherbein's overruled in kind of 3 separate ways. The first way is Gates says a constitutional violation has to be considered totality of the circumstances, whether there's probable cause to issue a search warrant. We're not looking at a factor test. We're not looking at the 2-prong test. We're not requiring that these boxes be checked. What we're saying is, in totality of the circumstances, is there a fair probability that evidence would be recovered? That's way number 1 that Sherbein's overruled. The second way is that, again, the statutory interpretation of 786.53 is no longer good law because 786.53 changed since then. The legislature changed the wording of it. So expecting that a statutory interpretation of a previous version of the statute should hold true isn't justified, in my opinion. And then the third, as we've already talked about, Hawkins overrules Sherbein in its conclusion that evidence should be suppressed. So Hawkins says, hey, even if you have a statutory violation here, suppression is not necessarily the remedy. We should not suppress based on this. And like I said, explicitly, it says we are overruling Sherbein. So I would argue that Sherbein has 0 relevance to what we're talking about here, being overturned in 3 ways as it was, but it is kind of instructive to see why this logic and why requiring these things is not appropriate, because that's where the case law came from. But now we have Illinois v. Gates, now we have Hawkins, now we have Keller and Sellers as our good law. So now I want to move on to the facts here. again, we're talking about totality of the circumstances. And the way that defense writes this brief, looking at it paragraph by paragraph, is taking out things one at a time and looking at them individually and saying, well, this doesn't prove anything. This doesn't mean anything. This doesn't connect anywhere. But that's not how the analysis should be done. The analysis is totality of the circumstances. And yes, even innocent things can be used to connect what's going on. So first, in this case, we have a confidential informant. That informant says, hey, we have three people. We have Mark Swanigan, we have Danielle Norris, and we have Ed Brown, I believe is the third one. These three people, they are over at this house, the 6455 address, and I forgot the street right now, but they're at this address, and they are dealing cocaine. And also, Mark Swanigan carries with him, he was armed with a black handgun. That's the stuff that we have together. Okay, so now police, like I said, could have just taken that statement, written it down, and sent it in and asked for a warrant. If they did so, 78653 would kick in. Now we're saying, okay, well, how does this informant know that? Right? We need something to say how they know it. We need something to say whether they're reliable or not. Have they consistently given good information? So all of that. But the police didn't stop there. They said, okay, well, let's do some investigation. Once we have investigation, 78653 isn't in anymore, according to Keller and Sellers. Not applicable anymore. Police say, okay, let's do some investigation. When they investigate, they say, oh, look, Mark Swanigan is here. He's standing on the lawn. They say, okay, the fact that the informant says, hey, Mark Swanigan is at this house and there he is, that means that something is right at least. There's some information that's connected, right? They see Danielle Norris. They see Ed Brown. They go, okay, this makes sense that these things are happening. There's also someone who's on a bicycle leaving the area. That person is detained and asked questions. That person said, hey, I went to that 6455 address. That's where I came from. And when that person is searched, that person has cocaine on them. So now that's added. We add that to the picture. Police also see in their surveillance of this house, they see a truck drive up. Someone gets out of the truck, walks into the house, is there for a minute, walks back into the truck, and drives away. And the police officer, Detective Winkrowski, says in his training and experience, which is very, very extensive training, very extensive experience, that's consistent with a hand-to-hand drug transaction. Now, they also are running lean checks and doing background checks on these people. When they get these names, they say, okay, the owner of the house is Mr. Brown. Okay, that makes sense. That, again, further corroborates what the confidential informant is saying. Altogether, this picture is emerging. When you put everything together, this is what we're seeing. And that's where the running that background check and the lean checks, that's where, okay, these people have warrants out for their arrest. These people also, specifically in the case of Swanigan, Mark Swanigan had been connected in previous investigations to narcotics and firearms and had been recovered in the same area as those narcotics and firearms. So police putting this together, they see this picture and they say, we believe that we have probable cause. And the magistrate agrees. The magistrate makes the same conclusion, says, hey, all this stuff together, the picture is adding up, right? There is a fair probability, again, that what we're looking for, is there a fair probability that contraband, in this case, cocaine, would be found in this house given everything we see? The magistrate says yes. So now the question for this court is, when the magistrate made that conclusion, was there a substantial basis in the search warrant for that conclusion? Not would the court have made the same determination, not if it started over, would we want more or not? Why did the police not do this other thing? Or, well, shouldn't there also be? The question is, given the informant's information, which the court can consider, and the magistrate did consider, given that informant's information, given the corroboration that was done to corroborate what the informant said, and also given what the police saw and observed as a complete picture, is there a substantial basis to conclude that there's a fair probability that contraband would be found in this house? And I think that the answer is very clearly yes. Together, this does paint the picture that there's probably something in that house that would be contraband or would be recovered by the police and would be incriminating. I do also just want to talk about kind of the two factors. If the focus is still, is this witness credible? This confidential informant, is that person credible? Then we talk about details that can be corroborated. Like I said, we have specific names. We have a detail that's included that he's carrying a black handgun. A black handgun was recovered from the house. If I think that the protection of that box that again previously had to be checked, but now can be considered, but doesn't have to be checked. The consideration there is that it's not just a rumor that's going around, right? Like, oh, rumor has it that somebody's in that house dealing drugs. That wouldn't be sufficient. That's not good enough. What the question here is, how would that person know that? But we also have an extra detail, right? Not just the names and the address, because that could just be, oh, this person's at this house doing this thing, right? The rumor around town is. But we also have an added detail that Mark Swanigan would be carrying a black handgun. Like I said, a black handgun was recovered. That extra detail shows that there's likely some personal knowledge here. So even under the 786-53 standard, that assertion, the statements made, allow the conclusion of a magistrate to be that this person's speaking with personal knowledge. And then also when we're talking about reliability, again, the court can consider reliability of the confidential informant under this totality of circumstances analysis. And when we're talking about reliability, again, 3 specific names, that one of the named persons, hey, that person owns this house. We also have, like I said, all 3 of these people are observed in or around that house in a short period of time of surveillance. So that's again a conclusion that's corroborated. And then putting that together, I think we can see this case is very similar to Keller and Sellers, right? Both of those cases, you would need both things. Both by themselves could be kind of maybe not be enough for probable cause, but having, I think, most similar probably to the copper Toyota, right? By itself, a copper Toyota leaving a place with cocaine in it wouldn't mean anything. It wouldn't mean that there's probable cause to search the house it just left. It could have gotten that cocaine from anywhere. It could be, they might not even know the person. How could you make an inference that there's cocaine in a house? But that piece of evidence, combined with the fact that someone told the police, hey, a copper Toyota is going to be delivering drugs to this house, put together, now it's clear. Oh, that makes a lot of sense that would be connected, that together, that indicates there's a fair probability that there are drugs in that house. Same thing here. We have someone leaving the place on a bicycle who says, I came from there and I've got cocaine. We have a confidential informant saying, hey, they're dealing cocaine out of that house. We see what looks to be a hand-to-hand transaction done inside the house. So we don't see the hand-to-hand, but everything that is observed is consistent with that. And we see all the people who the informant says should be there. They're all there. The picture adds up in I would argue even more strongly than in Sellers, in the Toyota one. So given all of that, I would ask that this court affirm the magistrate's decision that there is a substantial basis for that conclusion that in the search warrant, the search warrant and the affidavit have enough in them to allow the inference to be made that there's a fair probability that contraband would be recovered from this house. Thank you.
One more. Go ahead, Ms. White.
Yes, Your Honor. With regards to rebuttal regarding this, the arguments that the prosecution has made. In terms of case law, yes, I did cite several cases in this in this motion, such as People v. Keller, we have to look at the actual case. We can argue, well, I don't think that's enough. I think it was overturned. But we have to look at actually at the corroborating information and language in these cases. In People v. Keller, it specifically indicated that the task of the magistrate considering whether to issue a search warrant is simply to make a practical, common sense decision whether, given all the circumstances set forth in the affidavit before him, including the veracity and basis of knowledge of person supplying hearsay information, there's a fair probability that contraband or evidence of a crime will be found in a particular place. And they cite USCA Constitution Amendment 1 plus People v. Keller. So yes, there's information or statements or just information in that case that there was a trash pull. We have to make a comparative. Was there any trash pulls? Was there any drugs found prior to this search warrant being issued? Was there any evidence of any drug hand-to-hand exchanges or drugs on the ground, in the house, right at the porch? No evidence of narcotics prior to this search warrant being executed. Pursuant to MCLA 780.653, it specifically indicates that an informant's personal knowledge of information establishing probable cause for search, which is required if informant is unnamed, should be derived from information provided of material facts, not merely recitation of informants having personal knowledge. If personal knowledge can be inferred from stated facts, then that is sufficient to find that informant spoke with personal knowledge. We also have here in People v. Harris. This is also goes back to the personal knowledge. In People v. Harris, the court believed the specificity of details provided by the informant in their case regarding the shipments, dates, and defendant's name and address were substantial indicia to support a finding that informant spoke with personal knowledge. In addition, the affiant conducted an independent investigation that produced corroborating evidence substantially verified to the information supplied by the informant. What we have here is a young lady on a bike that goes to the house, leaves. Is there any evidence of a drug transaction at that actual house on the date in June of 2021 from that bicycle and the lady and the person people at the house? No. She indicates she's coming from 6455 Bannon. Coming from. She didn't indicate, I bought drugs from a person named, let me identify him in picture, Mr. Swanigan. She didn't identify who, if at all she even bought drugs from that house. All she did say is, I'm coming from. Is that an actual interpretation of coming from means I went and bought and engaged in a drugs transaction at that location because I just had drugs on me that I don't even know how long these drugs were on me by the time the officers even had any contact with me? No, that's not information that could be devolved in actual drug sale or trafficking at that house. Now, in terms of the informant, what we have here is all the informant indicated in June of 2021 is that drug trafficking is occurring at this house involving Mark Swanigan, Danielle Norris, and Earl Brown. Outside of that, what actual personal knowledge, what details was provided? Was there a date, a time? Was there a location in the house or at the house? Was Mark Swanigan at the house when this drug sale was going on or trafficking? Or was he outside the house? How many drugs were being sold? Nothing. All this informant makes is a blanket statement with no specificity. Did this informant indicate that he actually was involved and participated in this drug sale, trafficking? No, just a main statement. And a handgun. Where did this handgun even come from? A handgun was supposedly found at the location outside of the house, but when, how, and when was this handgun even observed on Mr. Swanigan? Throughout all of these statements that are supposed to corroborate the affiant's statements, what does the affiant have to corroborate any of these statements that were made? The affiant never indicated that he corroborated by observing Mr. Swanigan at the house, on the porch, engage in any hand-to-hand transactions or whatnot. There was no corroborating evidence other than a car coming in, and I could go into my mother's house and get some groceries and come out. Does that mean that I'm drug trafficking? There was no even observations of any drug trafficking other than a vehicle going into the driveway, going into a location, and going out. Is that enough to even establish that there was any drugs involved or any illegal activity? No. So what we have here is we have to have this informant must provide personal knowledge to even rise to the level of probable cause. Just an individual saying, oh yeah, they're in drug trafficking, they're trafficking drugs. When, how, when, in what way? Nothing provided. So People v. Broilo, of course, as APA Tyler indicated, he cited this case, but it doesn't matter. You can't interpret. It's a case. We can't sit there and start interpreting, well, I think it meant this, I think it meant that. Oh, it didn't mean that they were doing this. It specifically indicates that there must be something more than the mere fact that people are coming and going at premises to be searched to give reasonable cause to believe that criminal activity is continuing and presently occurring. Such additional evidence could be determined information or suspicious actions of the parties. People v. Broilo. What do we have here? My client's just standing on the lawn. Is he involved in any drug transactions, any type of suspicious activity? I don't think standing on the lawn establishes someone being involved in drug activity unless they observe my client at the location in some type of suspicious activity, going back and forth with their hands or whatnot, or observe drugs being passed by each other. And who is the other person? My client wasn't located as having any contact or being seen when this black truck came in, nor when a bicycle came to the house and left. Where was my client? Nothing in the affidavit indicates that, because specifically in the affidavit, it indicates that, one moment, Your Honor. Mark Swanigan was not listed in the affidavit as being identified or observed participating in any of the activities that were supposedly going on with no observation of any drug activities. So, Your Honor, I believe this matter really rises to probable cause. If we open this up, this type of situation, this puts a lot of people in peril. I could be standing at my porch just because I have a prior warrant. Oh, he must be involved in drug trafficking. All the citizens all over the United States or the world could be put in a situation where just because they're on a lawn, at a lawn, there's nothing observed of any type of illegal activities, but because we know his past and who he is and what he may have done or what he may have not have done in the past, suddenly he's a drug dealer. Danielle Norris, Earl Brown, nor Mark Swanigan were ever observed in any type of engaged in any type of drug trafficking. This is all hearsay, and it's false, it's misleading and untrue hearsay. We have to have more personal knowledge. This affiant would need to state, I observed Mark dealing drugs on June of 2021, and he had a handgun. What does that show? He observed he was engaged, the affiant was engaged in Mark. He could say, yeah, they were drug trafficking, but give more details. Was he next to Mark Swanigan? Was he holding Mark Swanigan's hand? Was he standing right here, 4 feet, watching Mark Swanigan or Danielle Norris or Earl Brown? No, it's just a blanket statement with no specificity. And there's no material facts. Date, time, location, when, how, other than at that location. So I would argue the fact that why didn't these officers leading up to this actual execution, a week, 2 weeks, 3 days, why didn't they sit there and perform surveillance? Why didn't they want to confirm themselves that Mark Swanigan was indeed at the house, in the house, or doing something illegal or participating in illegal activities? There's nothing in the warrant. There's nothing in the search warrant to indicate any of that. So we have to look at really what all of these factors include. We can use case law in all of these factors, but we have to show within the case law were actual activities perpetrated to establish probable cause. In this matter, I would just argue the fact that People v. Shervine, it also indicates whether a search is reasonable is a fact-intensive determination and must be measured by examining the totality of the circumstances, also cited by the USCA Constitution. What do we have? I'm just standing here. We're just standing here. Am I involved in drugs? Drug transactions? Mr. Swanigan was just standing on the lawn. That is the only identification they were able to make of Mr. Swanigan at the location before executing the search warrant. Danielle Norris and Earl Brown. Earl Brown was just coming in and out of his house. What does that show? Nothing. Danielle Norris wasn't even located or identifying the search warrant to be involved in any type of opening the door, giving someone something. Nothing. So there's just no evidence or testimony through this affiant, who had no personal knowledge, clearly, because it wasn't even put in the search warrant, that there was any drug trafficking other than blanket statements. And I don't believe blanket statements rise to the level of believing that there was actual drug trafficking at the house to be enough to execute this search warrant. So with that, Your Honor, I would ask that this be suppressed. There's not enough. If my client was in there and they were observed, there was a trash pull. He was at the trash bag and he was actually trash can, and he was observed coming in and out of the house, or he was one way observed having interactions with the house in the bedroom, in the kitchen, or whatnot. And then subsequently, he actually possessed or owned the home. And then they found some drugs in the house. Yes, we already know when you're in the curtilage of your home that you own or possess, that could put you in a position of being probable cause for having something to do with illegal activities or illegal drugs. My client was nowhere. He was never identified other than standing on the lawn. So I'm not sure how this would rise to the fact that, yep, he must be the one drug dealing. So along with Daniel Norris and Earl Brown, there's nothing. So I'd argue that this search warrant be quashed.
Judge, may I respond? I promise I'll be brief.
Just one
Your
more.
Honor, I don't believe he's entitled to us.
Well, he's not, but I'm going to allow him to, and then you can respond to what he says. Just one moment.
Okay.
Because I have a question for Ms. White. Ms. White, aside from the probable cause determination itself, let's assume for the sake of argument that I agree with you. Do you disagree that suppression not being the remedy is not what the case law has held? And I'm trying to recall which case it was.
Hawkins, Your Honor.
Thank you.
Can you repeat that? Because
So do you agree or disagree that Hawkins held that suppression would not be the proper remedy, even if I determined that there was no probable cause for?
I believe that, let me see, what page, because I have so many pages in this. Did I cite it? Because I just need to pull it.
I believe that I cited that case, Your Honor.
I'm sorry.
Yeah, because what
That
page
was the
did you,
people's case.
what page are you talking about?
Bottom of page 10.
One moment, Your Honor, I apologize.
Oh, take your time.
Your Honor, I would just argue that this is actually concurrent. It is a statutory and constitutional violation. It's the law. It has to be, any type of search warrant has to rise to the level of probable cause. I don't see any here. So I believe that both the Hawkins and Harris, all of the cases that were cited that would, delineate suppression versus no suppression, probable cause is the main connection to the finding of whether a matter should be suppressed in terms of the motion that I'm bringing forward today. And there's no PC.
So are you arguing, Ms. White, that the statute 780.653 as it's currently written requires that there be something more other than an informant's statements when the informant is unnamed?
Well, Your Honor, in terms of 778 MCLA 780.653, we already see that the title specifically indicates judge or district court magistrate's finding of reasonable or probable cause, basis of finding, basis and contents of affidavit. I believe that this right here, specifically that statute, if it was just saying pretty much that if a person named is making affirmative allegations against another individual regarding suspicious activity, and there's nothing actually included in that statute, that's what we'd have to go by. But the statute specifically indicates personal knowledge. There has to be specificity.
I apologize. I don't think I posed my question well. My question is, do you agree or disagree that 780.653 really only applies in situations where there is an anonymous informant and only the anonymous informant's information was used as a basis in the affidavit for the warrant?
No, because section A includes named, and then section B includes unnamed. So it's unnamed or unnamed individual providing information. And what I see here from the search warrant, it was an unnamed anonymous source that provided information. And outside of that, we have to look at what other information was provided. And there's observations that really, in my legal opinion, were irrelevant to seeing someone coming back and forth, coming in and out of a driveway. But I believe unnamed, named, they're all included. And I don't believe there's PC or probable cause from any sources or observations that were provided.
Okay, thank you. Mr. Tyler, go ahead.
Thank you, Your Honor. First, I want to start with the people's position on Hawkins. MCL 78653 requires more than the constitutional probable cause standard, right? It requires probable cause be developed in a certain way. That when there's an unnamed informant, it requires that the additional things be put together that allow the magistrate to make an inference about that confidential informant. Theoretically, the magistrate could say, hey, there's plenty of probable cause here, but there's an issue with this inference, right? So the constitutional standard could be met, but MCL 78653 not met. Hawkins doesn't say anything about the constitutional issues. So it's not the people's position that if there's an unnamed informant that Hawkins means that suppression is never the remedy. Just that the remedy for a statutory violation is not going to be suppression. It could still be if no probable cause is found, yes, suppression would be the appropriate remedy there. So I want to make sure that the people's position is clear there. We're not saying that even a constitutional violation, suppression would not be the remedy. Just that now these two lines of cases used to be the same thing. This two-pronged test used to have to be satisfied both constitutionally and also statutorily. Now the constitutional requirement is a little different. And so if one is found in the other, is only statutory violation is found, then suppression is not the remedy there. So, did you want to address that first?
No, go ahead and finish your remarks, and then she's gonna have the last word.
Okay. In the rebuttal that we just heard, defense counsel has said we need to look at the actual language, and says look at the actual language, and then quotes from page 3 of her brief, which cites to MCL 78653 and reads something that is not in the text of MCL 78653. This personal knowledge of informant is required if the informant is unnamed. That's not text from MCL 78653. 78653 says if the person is unnamed, then these things are required. Affirmations that could allow the magistrate to make this conclusion.
Mr. Tyler, when you made that statement earlier, I didn't find it then. I still don't see. What language on page 3 are you referring to?
The top of the last paragraph. The quote from defense's brief is informant's personal knowledge of information establishing probable cause for search, which is required if informant is unnamed, should be derived from information provided in material facts. That sounds like case law. There's not a cite other than to the statute. And the statute does not say that. The statute says, if the person is unnamed, affirmative allegations from which the judge or district magistrate may conclude that the person spoke with personal knowledge of the information, and either that the unnamed person is credible or the information is reliable. So that's the first thing. I would ask that the court go off the text of the statute. Then, again, in saying we need to look at the specific language, defense goes to Harris. The language contained in defense's brief discussing Harris is not, if I put in correctly in the search engine, that's not in Harris. That Harris is not talking about deliveries. It's not talking about schedules or timing that are a basis to establish knowledge. Harris is about an OWI. And in Harris, it's a named informant. So again, there's nothing there. Defense relying on these two prongs, reading this personal knowledge thing in the statute, and then also putting this stuff on Harris. Neither of those things are any basis to stand on. Harris doesn't say what defense says it says. MCL 78653 does not say what defense says it says. The requirement is always going to be Gates and the fair probability. If the language is, if defense wants to lean really heavily into the 78653 requirements, that's okay. She can do that. But then again, once we're there, the remedy is not dismissal or suppression. The remedy there is different. And I would just, again, 78653, according to Sellers and Keller, only applies if it's only the confidential informant's information that is being used. Here, both are used. So I would argue that for two reasons, 78653 shouldn't lead to suppression, because we don't even get there according to Sellers and Keller. And also, even if we got there, we're not suppressing. The requirements that defense is asking for, well, we need dates and times, we need specific things, we need to observe a hand-to-hand transaction, all this stuff. If the court adopts that position, it is at odds with the Supreme Court of Michigan's ruling in Sellers. There was no hand-to-hand transaction in Sellers. This is the Toyota. Toyota drives up, drops something off. Well, there's not even evidence that it dropped it off. Just pulls up. They were told it would drop something off by the informant. They leave. Leaving, there is cocaine in the car. If we just had the bicycle and the house, and the confidential informant talking about the house, that would be Sellers. If we had two things that we both have, that's the exact same thing as Sellers. Hey, they're dealing out of there. Also, someone leaving is carrying cocaine. The same exact facts, but we have more than that. We have the other indications of reliability from the informant, and we also have an observance of what appeared to be a hand-to-hand, consistent with a hand-to-hand transaction by the officer in charge. So if the court says, okay, the standard defense is saying should be followed, then Sellers was wrongly decided, and that it should go to the Supreme Court, and Sellers should be overturned. That's not the job of this court to do, though. So this case has more than Sellers, and Sellers was more than enough. Also, I want to talk specifically about the part where it refers to Mark Swanigan particularly, right? Because this search warrant is for a house. This search warrant is for that 6455 Banner Street, I think is the street. That's the search warrant. Now, there are 3 addendums that include these 3 people, okay? And the addendums ask for permission to search the persons of these 3 people if they're found in a house. So we can do the analysis that's done in Keller. This is the pizza box. If the court agrees, the dissent is actually correct there. The court says, well, the majority never went there, so there's some discretion that this court can follow and say, you're right, the scope of the warrant was improper. And if in this case it's actually an issue and we ought to determine what the scope is. If the court gets that far, then the answer is, okay, we have plenty that says this house, right? Because the person on the bicycle doesn't say Mark Swanigan. The person on the bicycle says 6455 Banner. The confidential informant says he lives there, but says he's dealing out of this house. He's never observed any hand-to-hand transaction in this house. The truck pulls up. There's no evidence he's even at home. This is all true.
Sorry, did the confidential informant say he lived there? I missed that. I thought that the confidential informant said things that an inference was drawn.
I think that he was, I'm trying to remember the exact language, but he was dealing out of there or something to that effect.
I'll check the warrant.
But my point is, this is a lot of this stuff, as defense rightly claims, is focused on the house rather than Mr. Swanigan, right? why would you even include that Earl Brown owns the house and that he drove up in his truck and went inside if your focus is just Mark Swanigan? Those are all fair assertions. I would argue there's still enough for that addendum because the informant says that he would be there. He was there. Again, one time on the lawn, not that he was living there, that he owned it. That's not the assertion here. But if the court then says, okay, defense, you're correct. The scope of this warrant is too broad. They can search the house, but they cannot search. That addendum should be dismissed. That addendum should be gone. They cannot search the person of Mark Swanigan just because he lives there where drug trafficking is going on. Nothing was recovered from the person of Mark Swanigan. Everything was recovered from the house. So even if the court gets that far, says, okay, actually, defense, you're completely correct. We need to look at this. And also you're correct on your reading of Keller that the dissent there's some room there that I can follow the dissent's opinion because the majority never addressed it. Once we get there, all that does then is say, okay, that little addendum that says we also want to search the person of Mark Swanigan, that gets dismissed, and everything recovered from Mark Swanigan is suppressed. Nothing was recovered from Mark Swanigan. So it doesn't get us anywhere. So that distinction, I think, is also important because a lot of defense's claims that there's gaps in this or that they should have expected to see these things are specifically referring to Mark Swanigan, not to the address. And the search warrant is to search that address. So altogether, I think, again, there's a fair probability that some contraband would be found if this apartment was or this house was to be searched, and there was a substantial basis for the magistrate to make that conclusion. Thank you.
One moment, Ms. White. Go ahead.
Yes, with regards to MCL 780.653, Section 3 indicates that the judge or district court magistrate's finding a reasonable or probable cause shall be based upon all of the facts related within the affidavit made before him or her. Now, this affidavit may be based on information supplied to the complainant by a named or unnamed person if the affidavit so there's a condition. If the affidavit contains one of the following, if the person is named, affirmative allegations from which the district or district court judge magistrate may conclude that the person spoke with personal knowledge of the information. Section B also includes person spoke, if they're unnamed, spoke with personal knowledge of the information. Accompanying this statutory, there's several cases that I discussed. Even in People v. Keller, the United States Constitution Amendment, People v. Harris, what is also always most pretty much consistently notated in those cases, personal knowledge. What we have here is an individual that claims that there was drugs being sold out of the home, but we don't have any more details other than crack cocaine was being sold out of the home. Specifically, paragraph 11 states that the affiant indicated that in June of 2021, not July 15th of 2021, affiant received information that from another officer, not even this affiant, Wengrowski even received this information directly from the informant, that this trooper or Officer Lane received information provided by an anonymous source stating that crack cocaine was being sold out of 6455 banner in the city of Detroit, specifically Mark Swanigan, Daniel Norris, Earl Brown. What we have here, again, is that it was the only statement. That's the only statement. Now, did this anonymous source indicate, well, on this date and this time, I was involved in I observed directly on this date time that Mark Swanigan dealing drugs or trafficking, Earl Brown trafficking, Daniel Norris? The supposed corroborating information in the affiant just included a car coming in and leaving, and then Earl Brown's car coming in and going in the house. Now, included in that four corners of what is indicated in the warrant, what outside of that indicates that there was drug trafficking? Oh, now they're trying to use a lady on a bicycle that has drugs on her. Did that observation even include or basically point my client to having anything to do with that situation or Daniel Norris or Earl Brown? No, It's not, there's no specificity. There's no probable cause that there was any drug trafficking. This could have been from Joe Blow or Mike Smith or who not. But there's no evidence that there was even drug trafficking in the house, other than an anonymous source indicating he observed drug trafficking, specifically Mark Swanigan, Earl Brown, and Daniel Norris out of 6455 Banner. But outside of that, when, how, when, what? There's nothing. And there's no corroborating testimony, well, evidence to even corroborate this anonymous source's statement, other than, oh, well, guess what? I saw drug trafficking, but I can't tell you when, where, how. Was it in the backyard? Was it in the front yard? Was it on the porch? Was it in the house? Nothing. So we can claim and argue that there's enough to show, but there's no personal knowledge. We need more than just a blanket statement. And then to corroborate that, Trooper Wengrowski didn't observe a drug trafficking transaction, anything of that sort. Lieutenant Payne didn't observe drug trafficking. All they received information from was an anonymous source that had really nothing to corroborate his statements other than a statement and nothing to corroborate that anything was occurring, period, from these officers. So I would just argue that there's not enough. We have to show all the case law that there is some more than just like in Keller, there was marijuana. Was that even used to the point that they believed there was probable cause? No, they did not observe prior to executing the search warrant any evidence of drug trafficking from that home to another person. A person driving into a driveway, going into a home, and then walking out with nothing observed on the person's hands or not whatnot. How can anyone just reasonably, common sense, oh yeah, that's a drug transaction? It makes no sense. There's nothing to show. My client was merely present on a lawn. How can you connect someone being present on a lawn connected to going in a house, having crack cocaine, and going to deal with other people along with carrying a handgun? There's nothing other than a statement with no specificity and no personal knowledge. So I'm asking this matter to be quashed.
Thank you. Okay, we're gonna come back for the court's ruling. Madam Clerk, please select a date in early March. So, Council, we're looking at early March. Are there any bad dates? And for the ruling, you need not appear in person. Everyone can appear on Zoom. You too, Mr. Swanigan, if you like.
Early March, because I know May's the jury trial. I will be out of the country the 10th through the 18th. So
Okay.
other than that,
Not the 10th through the 18th.
but I'll still, if it's through email, I'll still
yeah.
receive it.
You're out of the country. You don't need to.
Thank
You
you.
don't need to do that.
I'm trying not to do any work. Take my time off.
You need it.
Judge, just a personal request. Can we do the end of February?
Yes, it can be at the end.
Is that okay?
Oh, yeah. Just make sure. February 28th.
And that will be in the afternoon.
Okay, and that will be in person or you said it'll be on.
It can be. It can still be on Zoom. Yeah,
Okay.
I'll just be giving the ruling. So no
I'm free.
evidence.
1 o'clock.
Does 1 o'clock work? What date was that? I'm sorry, the 20. Does that work, Ms. White?
Yes, it does.
Mr. Swanigan, does 1 o'clock on February 28th work for you?
Yes, ma'am.
Okay, we'll see everyone then, again on Zoom.
Thank you.
Thank you. We're off the record. Everybody have a good day.
You too.